Good morning, and thank you for joining our session today. We hope everyone is keeping well and enjoying some of the freedoms that have been brought by the relaxing of the lockdown measures, along with hopefully a little bit of spring sunshine wherever you are. For those who don't know me, I'm Andrew Dunning, and I'll be joined for today's webinar by my extremely knowledgeable colleague, Mark Clayton, and we'll be splitting today's topics between us, just to keep you on your toes. We're also joined today by our marketing manager, the multi-talented Rachel McDermott, who's on hand to make sure that all our tech is working, and hopefully she won't have to prompt us to unmute our microphones at any point. So if we move on to look at the contents of today's session. So there've been a number of interesting and important employment law updates recently. So rather than just focusing on one topic today, we thought that we'd take you on a bit of a whistle-stop tour of several key questions and case updates, along with a reminder of the annual uplist for April as well. Our presentation will last for around half an hour today. So if you have any questions during the session, please submit them in the Q&A bar, and please make sure to include your email address for there as well, just so we can follow up with you afterwards if we don't get time to answer them today. We'll also share the slides and a recording of today's session so that you can refer back to them if you want, or share them with your teams as you see fit. Okay, so on with the presentation then. And the first question we will be looking at is, can no jab mean no job? So if we move on to the next slide, we are, of course, talking about the coronavirus vaccination program and whether it's possible as employers to require your employees to be vaccinated. So this is a topic that a lot of our clients have been asking about recently, and it's also generated a lot of news headlines, which you may have seen. There are multiple aspects to consider as part of this question. So a useful starting point is to think about whether vaccination could become mandatory across society in the UK, or for employees in certain sectors, perhaps. So as it stands, the government has not legislated for the vaccine to be mandatory for anyone. However, on the 14th of April, so just last week, a consultation was opened on whether to make vaccination a requirement for those working in older people's care homes. And that consultation proposes that an amendment is made to existing legislation to basically require care home providers to only use staff who have received the vaccine, or those who have a legitimate medical exemption. There are also some reports last week that some London NHS trusts are preparing to make vaccination compulsory for workers, so there are likely to be some further developments on this area, so we will keep you updated. I'm sure that we've also heard a lot of speculation around COVID status certificates, or vaccine passports as they're more commonly known. So the government is carrying out a review into whether they could play a role in reopening the economy, reducing restrictions on social contact and improving safety. This review is going to assess a number of things, including the potential use of vaccine passports to enable access to various settings, and that could include workplaces as well. So the government is due to set out its conclusions in advance of step 4 of the roadmap, which is due to start no earlier than the 21st of June. So again, we'll keep you updated on this. If we move on to the next slide, then we can consider the key question of whether an employer can require its employees to be vaccinated against COVID-19. So we suggest breaking this down to think about new starters and existing employees. So firstly, in relation to new starters, employers can decide to insert a clause into their employment contracts requiring new staff to have the vaccine. However, that will have consequences, as there may be various groups of potential applicants who might not be able to meet that requirement. So for example, those with autoimmune conditions, pregnant women, those with allergies to any of the ingredients of the vaccine, and also those who oppose vaccine on the grounds of their beliefs, so be it vegan or anti-vaccination in general. So where that reason relates to a protected characteristic under the Equality Act, so for example, pregnancy or disability, or religious or philosophical belief, that may give rise to claims for discrimination. As employers, you'll need to weigh up the risk of those claims and the associated costs to your business, both financial and reputationally, with the advantages that having all new starters vaccinated will bring. In respect of existing staff, an employer's ability to require them to be vaccinated will generally depend on their existing contractual terms and whether it's considered a reasonable management instruction to require them to be vaccinated. So again, similar groups of people are likely to be impacted, which can give rise to potential discrimination claims, but also for your existing employees with those up to 2 years service, that could lead to potential constructive dismissal claims as well. So there would usually be a change required to existing contracts of employment, and that generally requires a period of consultation to be followed, as well as agreement to be reached with your impacted employees. In some situations, employers may seek to impose such a change unilaterally, but we'd always caution that taking such action usually attracts a significant level of risk. So rather than making this a contractual issue, many employers are amending their policies to strongly encourage employees to have the vaccine instead. And we'll still need to consider what steps to take for those that don't, which could in exceptional cases lead to dismissal. So if you have any employees who do not wish to or refuse to be vaccinated, then having a blanket policy to dismiss all those who won't will almost certainly lead to successful unfair dismissal claims, and obviously the potentially huge financial and reputational consequences of those. However, we think if you deal with each case on an individual basis instead, in some cases a fair dismissal for not having the vaccine may be possible. It'd be really vital to ensure that you have a very strong and objectively valid reason for requiring the employee to have that vaccine. And you also need to consider the situation carefully and explore any other arrangements before considering dismissal, some of which we'll come on to discuss shortly. You'd also need to make sure that you follow a fair and proper procedure if you did decide to go down this route, and we would suggest seeking further advice before choosing to do so. There are also some other key considerations to take into account when weighing up whether to require your employees to be vaccinated. So currently, as you may be aware, private vaccination is not available. Individuals have to wait their turn, so in terms of their age and priority, to be offered the vaccination. So allowing only vaccinated employees to come back to the workplace could potentially lead to indirect or direct age discrimination claims by younger employees. However, it is possible to defend such claims where the measures can be justified as proportionate means of achieving a legitimate aim. You'd also need to consider health and safety grounds in terms of the extent to which the vaccination reduces the risk of transmission of the virus, which is unclear at the moment. The current advice is that vaccination is not a substitute for workplace COVID secure measures, which employers should continue to comply with. And there are also data protection implications to think about in terms of requiring employees to provide information on their vaccination status. So we need to bear that in mind as well. If we move on to the next slide, then we can take a quick look at some of the alternatives to mandatory vaccination in view of those risks that we've just discussed. So we would advise employers to consider how best to achieve voluntary vaccination within your workforce through encouragement and information. So you should be informing staff of the potential advantages and disadvantages of vaccination to assist them to make an informed decision. So that might involve consultation with employees or trade union reps, in addition to having a sensitive internal communications plan to try and assist that voluntary take-up of the vaccine. Employers may also wish to consider offering paid time off to attend the vaccine appointment, as well as paying for any time off required due to side effects following the vaccination. Another alternative to mandatory vaccination could be regular testing on a weekly basis, for example, and with free testing now widely available to all, that can ensure employees who do test positive can self-isolate and do not attend the workplace to avoid transmitting the virus to the colleagues. As we've already mentioned, employees should conduct regular health and safety reviews as well, just to ensure that they're up to date and properly implementing the COVID secure guidelines for their particular industry. Employers should also consider allowing employees to work from home, perhaps where possible, or temporarily changing their role or responsibilities to minimise the risk in the workplace. So in summary then, this area is a complex one, and we would recommend taking further advice given the likely importance of the vaccine in enabling businesses to succeed in a world with COVID and their obligations to safeguard their staff, their clients and their customers. I'm going to now hand over to Mark, who's going to talk us through the next topic.
Yeah, thanks, Andrew. So I'm going to look at the question of whether we can negotiate directly with employees when negotiations with a trade union are at an impasse. I'm sure many of you may have experienced the situation of an impasse when trying to negotiate with a trade union. So on the next slide, we'll look firstly at the relevant legislation. So just by way of some background, in 2004, the Trade Union and Labour Relations Consolidation Act 1992, very succinctly named legislation, was amended to include section 145B. And this section essentially prohibits employers from making an offer to a member of a recognised union which results in their terms no longer being determined by a collective agreement, where that outcome was the employer's sole or main purpose in making that offer. But since it was introduced, there have been very few cases on how it should be interpreted. And there are fairly severe penalties if an employer breaches this section. So the compensation amount is set out in legislation. There's a mandatory award that's currently £4,341 per affected employee for a breach of this section. So on the next slide are the details of an interesting case that considered what this section means in practice. So Coastal UK Limited versus Dunkley. Coastal UK concluded a recognition agreement with Unite in February 2015. And part of the agreement that was reached was that there would be formal pay negotiations held annually, and changes to terms and conditions would be negotiated with Unite. Now, in October 2015, Unite wrote to Coastal initiating formal pay negotiations for 2016. And after a series of meetings between the union representatives and HR, the company proposed that there would be a 2% pay increase beginning in January 16, a 2% Christmas bonus, and for any employee earning less than £20,000, a further 2% increase. Anyway, the offer was eventually rejected by the union after a consultative ballot with its members. And I should say also that the offer was conditional on the employees accepting changes to overtime, sick pay and breaks. Coastal then made two offers directly to employees. Firstly, in December 2015, they wrote directly to employees offering the pay increase, as well as the bonus and changes to their other terms. And they gave them a warning that if the offer wasn't accepted by the 18th of December, then they would not receive the Christmas bonus that had been offered. And they also stated that it wouldn't be offered at a later date. In January 2016, they then made a further offer directly to employees that hadn't yet accepted the previous offer. This time they offered a 4% pay increase, and they warned that if the offer wasn't accepted, then they would terminate the employees' contracts. Some 10 months later, a collective agreement was finally reached on the pay proposals, but 55 employees brought a claim alleging that the two offers that had been made in December and January directly to the employees had breached Section 145B of the legislation. The employees alleged that that was an offer which, if accepted, would mean that their terms were no longer governed by the collective agreement, and therefore it was a breach of that section. Now, the tribunal and the Employment Appeal Tribunal upheld the claims. They said that the two offers did breach Section 145, that had they been accepted, then at least one term of the employment would have been determined by a direct agreement rather than a collective agreement, and that was prohibited by that section. The employees were awarded approximately £420,000 overall, which was based on the then statutory award of £3,800 for each of the two offers per claimant. Coastal then appealed to the Court of Appeal, and on the next slide we'll see that the court held that the relevant section covers two types of cases. So the court said that firstly, where an independent trade union is seeking to be recognised and the employer makes an offer whose sole or main purpose is to achieve the result that the terms and conditions of employment will not be determined by a collective agreement, then that is prohibited. Secondly, where a trade union is already recognised and the employer makes an offer to end collective bargaining for some or all of the terms on a permanent basis. But on the next slide, we'll see that there was a third type of situation that was considered, and that was the situation here. And that's where a trade union is recognised, terms are determined by a collective agreement, but the employer makes an offer that means on this one occasion only, if accepted, the terms would not be determined by a collective agreement, because that's what had happened here. Coastal had made an offer that, if accepted, would mean that on this one occasion, the employees had reached a direct agreement. And the court held that the section does not cover this type of situation. They believed that if this type of situation was covered by that section, then it would effectively give trade unions a veto over any direct offer to an employee concerning their terms of employment, whether it was major or very minor, and they, with very severe penalties if the legislation was breached. And they believed that that could not have been the purpose of the legislation, which was intended to prevent offers to take terms outside of collective bargaining on a permanent basis. So there's two things I would take away from this. Firstly, as the law stands at the moment, if you are going to make a direct offer to employees where there is a collective agreement in place, then you should make sure that it's clear that you're only seeking to amend the terms on this one occasion without collective bargaining. And secondly, it may be worth, well, firstly, I would always say, take legal advice if you're planning on doing it, but also it's probably worth waiting to see what happens with the Supreme Court, because the case has been appealed and is due to be heard by the Supreme Court on the 18th of May. So definitely one to watch out for. So I'll now pass back to Andrew, who's going to talk about Smith and Pimlico Plumbers and the impact on holiday pay.
Thank you, Mark. So yes, if we have a look at the next slide, please. So this was a long-running case in which the Employment Appeal Tribunal considered the question of whether a worker had the right to carry over their payment for annual leave in circumstances where the worker was permitted to take their annual leave but was not paid for it. So the Smith case considered the European Court of Justice case of King versus Sash Window Workshop Limited, in which the court held that a worker is entitled to be paid on termination for any periods of annual leave that have accrued during employment if they've been discouraged from taking that leave because it would have been unpaid. So the court found in the King case that it was not an effective remedy for the worker to have to take leave and then subsequently sue for holiday pay. And critically, the court held that there was no limit on the amount of leave that could be carried over in this type of case, because an employer that doesn't allow workers to take paid leave must bear the consequences. So understandably, a lot of employees were nervously anticipating the outcome of the Smith case. So this is quite a complex case. So if we take a look at the next slide, by way of a background, we have a bit of a recap on the relevant law in this area. So firstly, the Employment Rights Act provides that it is unlawful for an employer to make a deduction from a worker's wages unless either the deduction is required or authorised by statute or a provision in the worker's contract, or the worker has given their prior written consent to the deduction. In the Stringer case, which is mentioned on the slide there, the House of Lords held that workers can bring claims under the deduction from wages provisions of the Employment Rights Act in respect of unpaid statutory holiday pay. However, the ability to bring historical unpaid statutory holiday pay claims was curtailed to a large degree by the Employment Appeal Tribunal decision in Bear Scotland Limited, in that the EAT held in that case that where more than 3 months has elapsed between deductions, this breaks the series of deductions. Therefore, anything before the 3-month break can no longer be claimed. It's probably worth mentioning at this point that there is a pending Supreme Court case, which is due to be heard in June this year. So it originates from Northern Ireland. It's called the Chief Constable of Northern Ireland and Agnew. So that's due to be heard in June. So we'll be keeping you updated on that one as it progresses. Under the working time regulations then, Workers are entitled to be paid during statutory annual leave at the rate of a week's pay for each week of leave. And a worker who successfully claims that they have been prevented from taking holiday is entitled to just and equitable compensation. The regulations allow a worker to bring a claim where their employer has failed to pay them all or part of any holiday pay that is due to them. If we then consider the time limits that apply to these types of claims, a claim for unlawful deduction from wages under the Employment Rights Act and for unpaid holiday pay under the Working Time Regs must be brought within 3 months, beginning with the date the payment should have been made. And when an unlawful deductions claim is brought in respect of a series of deductions, the time limit begins to run from the last deduction. There is no provision in the Working Time Regulations for linking a series of non-payments of holiday pay, so the time limit runs separately for each individual instance of non-payment. An employment tribunal may still consider unlawful deduction from wages and unpaid holiday pay claims that are presented outside of those time limits if it's satisfied that it was not reasonably practicable for the complaint to be presented before the end of the 3-month period. However, there is a limit on that in that mere ignorance of that right to bring a claim or of the time limit or the procedure for making a claim won't generally satisfy that test. If we turn to the next slide, then we can talk through briefly the facts of this particular case. So Mr. Smith was a plumbing and heating engineer who worked for Pimlico Plumbers from August 2005 to May 2011. Throughout that period, Pimlico Plumbers maintained that Mr. Smith was a self-employed independent contractor with no entitlement to paid annual leave. Mr. Smith took some periods of unpaid leave, and on the 3rd of May 2011, Pimlico Plumbers suspended Mr. Smith. Mr. Smith regarded the suspension and his other treatment as a fundamental breach, entitling him to terminate the contract. And on the 1st of August 2011, Mr. Smith presented an employment tribunal claim for, amongst other things, holiday pay. The Supreme Court subsequently held that Mr. Smith was a worker for the purposes of the Working Time Regulations and the Employment Rights Act. And following the remittal of his case, an employment tribunal dismissed Mr. Smith's holiday pay claim on a preliminary point that it was brought out of time. The tribunal did not consider that the ECJ's decision in the King case entitled Mr. Smith to bring a claim in respect of unpaid annual leave that had been taken. And so Mr. Smith appealed to the Employment Appeal Tribunal. So if we move on to the decision in this case, we can see the Employee Appeal Tribunal dismissed the appeal and held that the tribunal had not erred in its interpretation of the ECJ's decision in King. The EAT held that the ECJ's decision in King only applies to untaken holiday, and employers do not have a potential liability in relation to unpaid holiday taken by workers over previous years. The tribunal had correctly interpreted the ECJ's decision in King as not being applicable in Mr. Smith's situation, and there were significant differences between Mr. King's situation and Mr. Smith's. The EAT also continued to rely on its earlier decision in the Bear Scotland case that a gap of 3 months or more between periods of unpaid holiday breaks the chain in the series of deductions. In terms of whether it was reasonably practicable for Mr. Smith to bring the claim on time, the EAT agreed with the tribunal, considering there was no real impediment to Mr. Smith making inquiries about his position and seeking legal advice to bring a claim. The EAT did, however, concede that there could be a situation where an employer's deliberate deception could create a situation where it might not be reasonably practicable for a claim to be presented in time, even if reasonable inquiries were made. So in conclusion, then, this decision should come as a welcome relief and clarification for businesses who do engage in independent contractors, in that provided that contractors do take unpaid annual leave, any potential liability for holiday pay will continue to be limited. I'll now hand back to Mark then for the next topic.
Thanks, Andrew. So I'm just going to talk about when costs can justify indirect discrimination, and also talk about the cost plus rule and whether that's changed. So on the next slide, we'll just start with a recap of indirect age discrimination. So there will be indirect age discrimination where an employer applies a provision, criterion or practice, so that could be a rule or criteria or requirement, to a particular age group, but it also applies that PCP to people who aren't in that age group. And the PCP, the rule or policy, puts people in that age group at a particular disadvantage, and the employer can't justify having that PCP in place. So just to give you an example, so if an employer were to advertise a position requiring at least 5 GCSEs without permitting any equivalent qualifications, then that criterion would put everyone born before 1971 at a disadvantage, because they're likely to have taken O-levels rather than GCSEs. So it would indirectly discriminate against those born before 1971 unless the employer could objectively justify having that requirement. Now, often when employers are implementing new policies on pay, it will want to rely on costs to justify its policy, its position. But employers have historically needed to be aware of the cost plus rule when they're trying to justify their policies. So on the next slide, we'll look at what the cost plus rule. So the rule essentially means that where an employer wants to justify its policy that may be indirectly discriminatory, it cannot rely on costs alone. There has to be another factor that justifies having the policy. And there was recently an interesting case that we'll look at on the next slide that helps us to interpret this cost plus rule. So the case involved Mr. Heskett. He was a probation officer for an executive agency of the Ministry of Justice called the National Offender Management Service, NOMS for short. And in 2010, the Treasury announced a policy of limiting public sector pay increases. As a result of budget cuts and public sector pay freezes, NOMS amended its pay structure so that progression up the pay scale took longer than it had before. And the changes meant that Mr. Heskett, whereas previously it would have taken him 23 years, whereas previously it would have taken him 7 or 8 years to progress to the top of the pay scale, it would now take him 23 years. So Mr. Heskett would earn less than his longer serving and hence typically older colleagues under the new policy. So Mr. Heskett brought an employment tribunal claim for indirect age discrimination, arguing that the policy put those under 50 years old, including him, at a significant disadvantage to those aged over 50. And the question in this case was whether this pay policy was justified as a proportionate means of achieving a legitimate aim. His employer relied on its financial circumstances to justify the new pay policy. Now, the tribunal and the Employment Appeal Tribunal acknowledged that costs alone could not justify the policy as a matter of law. However, they found that living within one's means was different to simply trying to save costs, and that living within one's means could be a legitimate aim that justified the policy. So it's quite a subtle distinction that they've made there between purely trying to save costs and the aim of living within one's means, which it said was different and could justify the potentially discriminatory policy. The decision was appealed to the Court of Appeal, and on the next slide we'll see what they said. So the Court of Appeal held, firstly, the cost plus principle is still applicable, that's still good law, and that the essential question is, can an employer can the employer's aim fairly be described as no more than a wish to save costs? The need to reduce expenditure or to balance the books could constitute a legitimate aim, because they held you can't look at things in a vacuum. You have to look at the financial circumstances that the employer is operating in, and it's legitimate for it to rely on a need to break even or balance the books. So the takeaway lesson from this is that where you're implementing a policy that may be indirectly discriminatory, but you want to justify it on cost grounds, you still need to have another reason, but that other reason could be the need to live within your means as a business and to balance the books. Quite a subtle but real distinction. So it's good news for employers, but you do need to remember that having a legitimate aim is only half the story. You still have to show that your actions are proportionate, which means considering whether there are any alternative ways of achieving what you want. For example, alternative ways of balancing the books that are less discriminatory. So I'll now pass back to Andrew, who's going to talk finally about the April Hub.
Thank you very much, Mark. Yes, so we have a quick recap now for you on the annual April uplifts. So if we move on to the next slide, starting with the National Living Wage and National Minimum Wage updates, which came into effect from the 1st of April. By way of a reminder, of course, these slides and the recording of today's session will be shared afterwards, so please don't feel the need to write all these down now. And also the rates are available on our slick new website, which is www.watershed.law, where you can keep in touch with the latest updates and also find out more about what we do at Watershed. So moving on to the final slide then, we have from the 4th of April, we have the standard weekly rates of statutory maternity, adoption, paternity, parental bereavement and shared parental pay, which will all increase to £151.97. From the 6th of April, the weekly statutory sick pay rate will increase to £96.35. The maximum amount of the week's pay, which is used to calculate statutory redundancy payments and other awards such as the unfair dismissal basic award, increases to £544. And finally, the limit on the unfair dismissal compensatory award rises to £89493. So that concludes today's presentation. Thank you again for taking the time to join. If you do have any questions or any suggestions for future topics as well, then please email us at our addresses, as you can see on the screen there. And hopefully we'll see you again for the next webinar in May, details of which we'll share shortly. Thank you all again for joining and have a good day.